Well, legal issues. First of all, I want to say this is not legal advice. But what I'm going to try to do is tell you the kind of issues you need to deal with. And the reason it's not legal advice is a lot of legal stuff is very fact specific. And so you may think it applies to you, but the facts make a difference. So that's the first thing to think about. The other thing is, as I started to put this together and look it over, I realized I have far too many slides to get through in the allotted time. So I'm going to walk through them at a good pace, and I have made some sort of sub videos for some of the things we won't cover, and I'll make sure that those are posted on the website so you can look at them separately. Okay, the way I'm going to approach it is a life cycle of a company, from idea stage to pre-financing to outside financing, and sort of walk through the things that you should think about as you go through this journey. All of these slides will be available afterwards, but feel free to take pictures. We're going to start with the idea, because to have a venture, you need to have some idea of what you're doing. And we're going to look at some of the things relating to who owns it and what can go wrong. And then we'll also talk about outside financing things relating to IP. So in general, intellectual property, if you think of intangibles as in companies, you have a market cap of a company. It's the number of shares times the price per share. Says, that's the value of the company in a public market. Over time, it's become increasingly clear that the intangibles are a bigger portion of the value of a company than it was 100 years ago, when it would be equipment and other types of things. So IP becomes very important in any venture as you're trying to build value. These are kinds of protection that you could have. At the top, of course, is none. You don't have any protection at all. That was a question that came from our stall guardian. Trade secret, which is what it says it is. It's something you keep secret. Trademark, copyright, patent, and a combination. So I'm going to walk through all of those. Trade secret is something you keep secret, and it can prevent others in the sense that if they don't know the secret, they can't do anything with it. Trademark and copyright can enhance value of a company, but they don't block others. In other words, you can think about, you have Coca-Cola and Pepsi. Those are two trademarks. They both have value as brands, but they don't block each other from being in the marketplace. Patents cut both ways. And that's the reason, as we'll talk about, is to get a patent, you have to disclose your invention. So inherently, you're letting other people know what the secret sauce is. But in exchange, you get a right to prevent others from doing that for a period of time. If you think about the duration, patents are probably the shortest duration. It's 20 years from the date of filing of the application in the US, and trade secrets can be there forever. The formula for Coca-Cola is the example of a trade secret. In terms of cost, it sort of goes the other way. I'm not saying trade secrets are no cost, because you do have to protect them. But if you go all the way to patents, you'll see that those are expensive. So it's sort of an interesting thing. Shortest lived duration is the most expensive. So we're going to go through each of these. And these are done country by country. That is, each country has rules relating to these things. I'm going to focus on the US. Other countries are different, but they're not that different. So I'll give you an idea. Trade secrets, something to keep yourself an advantage in the marketplace. Formula for Coke is an example. Protection varies from state to state. These are governed by state law. And they last as long as you keep them secret. It's typical to use non-disclosure agreements if you can, if you really have to reveal your trade secret. For your venture plan or pitch, you don't want to put any trade secrets in the pitch. The point is, if you can't articulate the value of what you're doing without explaining how you do it, then you got to figure out what the value is to a customer, all the things we've been talking about. Leave the details of the technology, et cetera, out of it. Trade secrets are typically, if you think about trying to prove someone's infringing your rights, if you have a process for something, it's hard to figure out whether somebody else is using that same process. So it tends to be covered by trade secret. If you file a patent, you have to disclose the process, and now everyone sort of knows what your process is. And now if you go to try to prevent them from using it, how do you prove that they're actually using your process? So often processes are kept trade secrets. Trademarks and service marks. Trademarks are the thing that goes with goods, and service marks, of course, goes with services. It's a name, or it can be a name or a symbol or a sound even, or a color that in the mind of the relevant consumer, they associate with your product or service. So examples, could be the lion's roar is an example of a sound. A famous one is the sound of a Harley motorcycle is actually a trademark. So if you tried to put a motorcycle on the road that had the same sound as a Harley, you might be infringing their trademark. The rights to a trademark arise if you actually use the symbol or the sound or the words in commerce, meaning you have to sell something or do something. There is something that came along a few years ago where you can file what's called an intent to use with the federal Patent and Trademark Office. And it says, look, I don't want to have to develop the product and put all the marketing and then use it in commerce and then find I have a problem. I'd like to know that what I propose to use as a trademark is going to be okay when I've invested all that money. So an intent to use filing says, I want to use this mark for these goods or services. You get sort of a provisional, yeah, okay, but then you actually have to use it within a reasonable period of time. Trademarks arise under common law, state law. So you don't actually have to register it, but you do get benefits if you register federally with the US Patent and Trademark Office. If you're just starting out and you want to put a mark out there, just put a TM, a little TM next to it to say, this is my trademark. When you file and you get the registered mark approved by the patent office, you can put the little R in a circle, which gives you priority over everybody else, except if there's somebody who was using that mark before you got your mark registered. The classic case was McDonald's, the Golden Arch restaurant is federally registered as a trademark. But there was a restaurant in upstate New York called McDonald's that had been there way before McDonald's, the hamburger joint, came along. They can continue to use that mark in the same area they were before. They can't expand beyond it. So that's the only exception. You want to pick something fanciful, something that's not merely descriptive. I once tried to get a trademark called microdose on small dosage aspirin for use in heart attack preventions. And it was rejected because they said it's merely descriptive. It's a small dose. And so we had to do something else. And you can check whether it's available. If you go to the US Patent and Trademark Office, you can search for a mark, see if it's used there. There are commercial services that do more extensive searching across state registries and everything, but it's a good starting place. I will just keep going. If you have a real, biting question, we'll try to take it, but I want to just move through as much as possible. Okay. Copyright. A copyright is a right to make and prevent copies of something. It's an original work of an author. So it comes about when it's created. So if I write a letter to my mother, I have a copyright in that letter by the mere fact of doing it. If I do a painting, I have a copyright in that painting in the sense that at common law, I can prevent it. Others, but the real benefit is to register it with the federally registered with the Library of Congress, actually, is where you do it. The duration is long. It's 70 plus years. The cost of registration is low, less than $100. The suggested notice, you put something to give people notice that you're copywriting is copyright, year, author, all rights reserved. You can see I've done that on my slide. When you actually register it, then you can put the little C in the circle. And that gives you the right to bring suit against someone if they're infringing your copyright. Now, for your venture, this is a real key point. There's going to be a lot of stuff I throw at you, but a few of the things are really key for a lot of companies that I've seen. The owner of a copyright is the person who wrote it or did it, the author. Okay, unless that person was an employee of a company doing it during the course of employment, or it is done under a contract as a work for hire. It has to be a contract. So an example was I had a client a number of years ago who had spent $500,000 developing a trading system for bringing imports into the United States. And he found out that the software company that he hired to write it was selling it to other people. And he said, well, wait a second, I paid for that. How can they possibly be selling it? Well, it turned out he never had an agreement with them as to who was going to own it. And in fact, he didn't own it. He owned the right to use the copy he had, but he couldn't prevent them for someone else. Now, this becomes an issue in startups because typically you don't have employees right away. You know, you have a team, maybe somebody's writing something, or you hire someone to do some coding, and you don't have unless you have an agreement in place, the company isn't going to own it. The flip side of it is, if you're a small company and as part of your customer discovery, you're dealing with a large company, or you're trying to, you got a project and get paid. I think you guys got paid something, right? The large companies know all of this, and they have a big form they give you that says, we own everything that you do, which of course can't really be the case, right? Because, so you have to negotiate with them a bit saying, you can own this provision and this thing. For one company I was involved with, we had a standard memo because we're dealing with very large companies. We had a standard memo that once people objected to our changing things in the agreement, I'd give them the memo explaining what our business is, how it works, what rights we can give them, and what rights we had to retain. And it'll allow us to get through the legal departments in bigger companies. You want to check the open source issue if you have software to make sure that you're using open source correctly and not incorporating it integral into your product without giving back the license under the open source license. Okay, I know I was going to get questions on AI and copyright. And it's established law in the US that it has to be a human being that creates the work. However, last year, the US Copyright Office came out and said, well, works created with the assistance of artificial intelligence can be copyrighted, but it has to have a significant human authorship. So if you, and that's defined, for example, where a human selects and arranges and makes a work out of the pieces that are maybe generated by AI. It's an open question how that's going to go once it gets in the courts. The rule I would have is just claim copyright anyway and see what happens. The other side is, can people doing AI, building AI systems, can they use copyrighted material as a training thing? Again, that's yet to be determined out there. And so stay tuned, just something to keep in mind. Okay, on to patents. Okay, so a patent is a limited time monopoly. As you'll see in a moment, it's the right to keep others from practicing your invention. Now, why we don't like monopolies? You know, we have antitrust laws. So why in the world would we have something that gives a limited time monopoly to somebody? Well, it goes back to the Constitution. It's even recognized in the Constitution. The theory is that if we give a limited time monopoly to an inventor in exchange for the inventor describing the invention, then what we do is we build up the body of knowledge. And when that monopoly expires, when the term of the patent is over, other people can build on it and go forward. So it's really a societal trade-off between, you know, preventing people from doing things and trying to build innovation. It has to be applied for, and it's granted country by country. It's very much like real estate. It's the right to, when you have a piece of real estate, the fundamental right you have is to keep somebody off your property, to prevent trespassers. Now, that doesn't mean you could actually use your property. Why would that be? Well, I might have to walk across your land to get to my land. I can keep you off my land, but I may not actually be able to get to my land if I have to cross your land. So it's really the right to exclude others from what you're doing. And a lot of people get that confused. And the rights are to prevent others from making, using, selling, or distributing or importing the patented invention. And there's the analogy. Now, the claims of the patent are like the fence around the property. So if you have a piece of real estate, there are meets and bounds, and you can get a surveyor's thing. In a patent, it's what is claimed is actually what's protected. So you can have a patent that describes all sorts of wonderful things, but it only is claiming one bit. That's the part that's protected. The duration in the US is 20 years from the date of filing, which sounds like a long time, except it can take a number of years to get through the patent office. And then meanwhile, you're out there trying to get your product to market, but it's still 20 years. Again, to illustrate the idea of if it's a right to prevent others, suppose you patent a vessel to hold a liquid, and you're able to get a patent because nobody ever thought of that before. It's novel, it's useful, and it's not obvious. Those are the criteria. Let's say you do that. And I come along and I say, gee, that's a great idea. I think maybe I could put a handle. Like I'll patent a handle. So I have a patent on the handle, you have a patent on the cup. There can't be a handle on the cup unless both of us agree, because I can keep you, I'm the owner of the patent on the handle. I can keep you from putting your cup on my handle. And you as the owner of the vessel can keep me from putting the handle on your vessel. And the only way to do that is to have an agreement you can do it. Okay, what are the requirements? It has to be new, I mentioned that. You have to cite to the patent office prior art, it's called. That is, anything that's published or patented, anything that's relevant to the determination of whether the invention that you're coming forward with is actually novel. It has to be useful. That's usually not a problem. It has to be patentable subject matter, which is defined as process, machine, manufacture, composition of matter, et cetera. So a lot of things have been happening in the last 5 or 10 years is around the ability to patent software. And there's a whole bunch of confusion in the courts as to what that means, whether it's clear if you have something that you know how to do manually and you code up something to do it in a computer, that's probably not patentable in its own right. So that's an area that's going to continue developing. The other requirement is the invention that you're trying to claim cannot previously been offered or sold or publicly disclosed in order to get the patent. Now, a disclosure has to be an enabling disclosure. So if I say, I have invented anti-gravity boots, I haven't told you how I do it. So that's not an enabling disclosure. Now, in most of the countries in the world, if you make a disclosure publicly, or it's viewed to be a public disclosure, before you file a patent application, you can't get a patent at all. So I was in Istanbul a number of years ago with judging some competition of companies, of entrepreneurs from the Muslim world. And this group came in from Egypt, and they talked about, they had a new way to compress wireless signals, and it was fantastic. And they were quite excited and looked pretty interested. And I said, well, have you filed a patent yet? Oh, no, we're thinking about it. Oh, okay. Have you published this? Oh, yes, we're in a prestigious journal. We'll be out, next month. And I said, possibly in the US, you can get a patent because you have 1 year in the US from the date you publicly disclosed to get an application on. But probably in every other country in the world, you're not going to be able to do it. And it was one of those, you can almost see their jaws sag. So that's my second important thing. The first one is, if you're using somebody to develop software for you, make sure you have a work for hire arrangement so you own it. The second is, do not disclose something publicly that you want to get a patent on or think you can without filing first. Those two very important things. I'll show you in the US how we got around this. We'll come back to that. The invention has to be not obvious to one of ordinary skill in the art. Another example here was MIT Venture Mentoring Service. I don't know if we talked about it, but it's a group at MIT has about 120 mentors that have a lot of experience. Any MIT-related person can go and, be part of a mentor team, have a mentor team there. There was an MIT professor had a great idea for something in the semiconductor space. And he said, well, it's sort of obvious. And I said, it's not obvious to me. You really ought to go check on that, because he wasn't going to do anything. He went and talked to a patent lawyer, did some patent searches, and decided, maybe we'll start a company. Well, 3 years later, he sold that company for $250 million. And he wasn't even going to do it because he thought it was obvious. So I don't know if they still have the expression at MIT where somebody says it's intuitively obvious even to the most casual observer. Is that an expression? That's usually means nobody knows what the hell it is. So, and an important other thing is we're under a first inventor to file system in the US. Before, it used to be the first to invent could get the patent. Now it's the first inventor who files. So that has implications if you're doing joint ventures, where there might be multiple inventors. Again, these are meant to be sort of red flags to keep in the back of your mind. Now, for new ventures, your investors are going to want to know, and of course, every time I say investors want to know, it means you also ought to know, because you're putting the time into the company that's worth more than the money of the investors, even though it doesn't quite feel that way today. Do you have a freedom to make, license, and sell your product? It's typical to go and get what's called a freedom to operate opinion from a law firm, if you're really serious about it, about launching. It says they've looked at something, and as far as we can tell, you're okay. If you fail to do that, and it turns out you willfully infringe somebody, you can end up with triple damages. So that letter saying your freedom to operate is important. And does your company own the technology? Did the inventor assign it to the company? Patents are issued to inventors. If you're inventing and you're with a big company, you've probably signed an invention disclosure and assignment agreement. You're coming to work for us as an engineer. Anything you develop while you're here in the course of thing, you're assigning to the company. And that's where you'll see on a patent, the inventor, and then there will be a company name. Was it licensed from a university? Some people try to sneak things out that really are owned by the university. When it gets time for money to be raised and people do what's called due diligence, where they go and look at all the facts and circumstances, they're going to figure out that you better have a clean title to the stuff that's coming out. A little bit later, I'll talk about how MIT works in that regard. And did it go into the public domain? Did you make an enabling disclosure? You can also, by the way, if you hold your product out for sale, that's also ticks the 1-year rule. So if somebody at a trade show that shows or talks about a product, maybe even shows a prototype, doesn't sell it, or maybe doesn't even show the prototype, that has been known to be able to tick off the 1-year rule. So that's what I basically said. We'll move along from that. Okay, prior art, find out what is out there already. And this is a company that I co-founded. It's called IP Vision. This is our free website, seetheforest.com. And where it came from is, as we were trying to figure out for our ventures, what the patent world looked like. It was excruciating to have to read all these patents and then try to figure out what was going. There are 5,000 new patents issued in the US every week. We had a company, one of the ones I talked about on the first night, where we spent close to $100,000, and it was a very good company that did a lot of great research. It took them 6 months to come back to tell us what the patent world looked like. Well, in those 6 months, everything had moved along. So we said there's got to be a better way. seetheforest.com. I'll show you some examples here. You can sign up here as a free registered user. And if you're MIT, send me an email. We upgrade you to premium, as part of our commitment to the MIT community. So what is it? This is one of the patent maps, an example of a patent map. On the left, you'll see the yellow patent there is a Tesla patent. When that patent issued, it cited all the other patents to the left of it as prior art. Now, why is that relevant? Well, it turns out if you know if you have knowledge of prior art and you don't cite it to the patent office, it's the basis for invalidating the patent, even if it would have been issued by the patent office had the patent office known. What does that mean? It means people view it as a fraud on the office. You knew something, you didn't bring it to the attention of the examiner, you're not entitled to the patent otherwise. And so these citations are very important. Unlike academic citations, where you might cite a bunch of other papers. This has real consequence. You might cite your professor's papers if you're in the PhD program, right? Because it would be not good politics to avoid your professor. So these lines, the yellow, all the boxes are lined up where the left edge, if you look in the upper right corner, the left edge is the filing or publication date in time. The horizontal axis is time. The tail to the left is when it was filed. The numbers in the box, you see in the upper right, it says 32,1. That meant at the time, that patent cited 32 other patents as prior art, and only one patent cited it. And the lines connecting the boxes, those are the patent citations. The map also shows you who are the owners, the current assignees of those patents. So that was a Tesla patent in 2010 to show you why you got to keep up on this stuff. 13 years later, that's the same patent. The things to the right are all the other patents that are citing it. And those are the companies. So one of the things when you look at these maps that we called it See the Forest is you're trying to figure out who's in the space. Are they, and why are they there? Are they potential competitors? Are they partners? Are they customers? Maybe potential acquirers. And so you're developing out your whole business strategy. This is an important component, especially if you're in a technology space. And if you build out a portfolio, this was Tesla in about, I don't know, 2008, 18, sorry. And there they are 5 years later. This map shows all of the patents that they have and whether they cite each other. So typically a company will have an initial patent and they'll do like, okay, we got the cup and now we're going to patent the handle. The handle is going to cite the cup patent. We're going to have this and event, and you see a cluster building out that shows they're investing in a product. We use maps like this called interconnection maps by doing keyword searches. We did one with a couple of those with the National Science Foundation SBIR program to help the SBIR grantees figure out where they should go to commercialize. And in one case, they saw a big bunch of patents there and they said, ooh, that looks like a patent thicket. We probably don't want to go there. There's some other application areas that we're going to pursue. A few weeks later, we did the same analysis, same looking map, but where there's a big cluster of patents, they started looking just at the titles and going over them. They said, well, actually, that's probably where we want to go because we think we've solved the problem that those patents are trying to solve. And that may be very exactly where we want to go. Those could be partners. They may even be people that would acquire us at some point. So having that sort of intelligence is important. I'm going to come back to the Tesla portfolio in a moment. Obtaining a patent. It's, inventors like to, if given an unlimited budget, they would patent everything, right? It's expensive. So the trick is, what do you want to patent and when to file, and you have to prepare the application, and then you have to do what's called prosecuting it. It's a weird world. We think of prosecutors as, the district attorney against a criminal, but you prosecute a patent with the patent office. The important thing is to figure out if you're going to patent something, what is going to add value to the company. And, would competitors use the technology? So instead of just saying, oh, we have a cool idea, think about it strategically. And the reason is, as you'll see in another slide, patents are expensive. There was a early 2000s study by the General Accounting Office that said that the costs for one patent over its life in the 10 major industrial countries range for small companies who paid less in fees, range between $250,000 and $500,000 over the life of the patent. So that's expensive. So you want to be careful. You want to file before you lose rights. And I've talked about that part. Now, this is an important part for startups. And in fact, large companies, we were doing with a very large company and we asked them, we were doing a collaboration and we started talking about doing provisional applications and they said, oh, we don't do that. So what is this all about? Well, you remember when I said if you don't file first before you disclose, you can't get a patent anywhere other than the United States? A provisional application is treated as an application for the US and for the whole world. So provisional establishes a time when you've actually filed. The important thing is you don't have to put claims in a provisional patent. You just describe your invention. I've even seen people take papers they're going to give at conferences, slap a cover page on it, file it. Filing fees are pretty low, and you just put it in, and it's deemed to be filed. You have to file the actual real patent application with claims within 12 months. But for short dollars, you can get a provisional applications. Nothing happens at the USPTO. The only downside is if you fail to disclose something in what you file, you won't get the same priority date. What does that mean? Suppose I had determined, nobody else knew this, that fruits and vegetables were important for human health. And I file an application on that. But in the course of the year, my research shows that you need protein too. And I never mentioned protein in my filing. I could file another provisional saying protein, but I wouldn't get that earlier filing date. When we developed out the IP Vision system, it was software as a service. We had releases every 4 to 6 weeks. Before we released, we'd sit down and say, what are we going to put out there that we think is valuable? Should we file an application on it? What did we think about but didn't implement that we might want to file an application on? And we went through a process every time we released. So we had a whole series of provisional applications that sort of anchored time in the sand. And so when we went to talk to people, we could say we have 10 provisional applications filed. Eventually, you have to bite the bullet and decide whether you're going to do the full application. We've used that kind of strategy in one company that I co-founded, where we ended up dealing with a very large consumer products company. And we had filed provisionals, and we had actually filed, then converted them to utility applications. And they were very interested in the collaboration, and we had pages of stuff. What would happen if the patents didn't issue? And after about 2 weeks of this discussion, I got notice that our patents had issued, both in the US, China, and Europe. And that sort of totally took that whole discussion off the table, and the whole deal went forward. But the reason we could do that is we'd done provisionals, then we'd done the utility patent, we'd moved things along, and the technology was ready for a commercialization. So has anyone filed a patent? Okay, so a few people. Okay, so basically, there's a description of the field of invention, a background, what's broke out there that your invention fixes. You have to summarize the invention, and then you give a more detailed description. One of the important things is you have to describe the best mode of practicing your invention. Because remember, the whole idea is you're supposed to disclose in order to get this limited time monopoly. So, some people say, well, I'll show one way we tried that really didn't work, but I'll keep secret the stuff that I know works better. That's not going to fly if you ever get into litigation. And then the claims, what exactly is your invention? Is good.
The question on the Zoom was, if you file a provisional patent, should you try to cover all the embodiments of an invention, or should you just get a preferred embodiment be covered initially and then other embodiments left to follow on provisional patents?
The trick on a provisional, often at the beginning, you really don't know what the embodiments are going to be. And so the trick is, can I describe something broadly enough that later when I go to file the full patent application, I can talk specifically about what I meant by the term sensor, maybe or whatever those terms are. So broad descriptions of things that later you can go and have a discussion with the patent office by, well, what I'm going to add now to the patent description or the claim is really what I'm talking about there. And it's basically a negotiation. And that's why, rightly, patent lawyers would say you're better to try to file a full utility patent where you think about all these things. But that sort of assumes that you've come a long way. You've done a lot of research development, and often with a provisional, especially as a startup, early stage, you've got an idea of where it's going to go. So you guys would be patenting, placement of articles on shelves, which isn't really helpful when you're talking about, what's happening in a stall. So your description could be around an idea of coordinating different sensors and visual things and having feedback loops and stuff. And then you can say, well, that's what we're doing with the stalls. I want to claim stalls. Here are the costs. It can be for a utility. Remember, the provisional is one you could just slap patent lawyers will often say, forget the provisional, let's file a utility. Because you really want the claims, you want to make sure it's all complete. Well, it costs anywhere from 5 to 15 or 1,000 or more to file a utility patent. So if you had unlimited time and money, why not? The provisional is the thing that entrepreneurs do. Now, I said 5 to 15,000. Here's a lesson learned. One of my co-founders, as we were filing a utility patent, he'd read the drafts that came back from the patent office, from the law firm, and he'd call them up and he'd change it back and forth. I get a bill from the law firm for $30,000. And we still haven't filed it. And so I had to talk about a discussion with your founder. All communication with the lawyers are going through me. We can't pay $35,000 for a patent application as a startup. So the filing part is pretty much can be controlled in terms of cost. The wild card is once you file it with the patent office, the examiner looks at it, comes back usually hopefully with an objection. If they say it's done, you probably haven't claimed enough. And you can't control how long it's going to take back and forth. And so it's a little bit of a wild card on that. Foreign applications go up quickly. You can file, there's a Patent Cooperation Treaty, PCT. You can file in a country and designate that as your PCT filing. It gives you time to get filings in other parts of the world. But once you do, now the costs start going up. You've got translation fees, you've got local fees, all of that. In the case that I described with our collaboration agreement with the consumer products company, we timed that one pretty well because we were able to pay to get the first 3 patents. And then our agreement with them, they paid all the prosecution going forward. So they picked up the bill, which started to run into hundreds of thousands of dollars going forward. Okay, so patents are expensive. You can't just file them all over the place. Is there another strategy, especially as a startup? Well, disclosure can be a strategy. If you, together with your patent lawyer, can determine that your invention is a critical, important thing, something really key, and that you think you can get a good patent on it. This is often happens through things out of MIT because we don't do everything's cutting edge here. Then you can think about filing that application and then disclosing all the other stuff to prevent what's called a picket fence. So remember I said the patent has the right to exclude others. So if I filed a patent on the vessel to hold a liquid and disclosed all of these other things, like a lid, maybe a sleeve, all the things that might make this commercially viable, maybe an insulating sleeve coming up, I disclose that. No one else can patent those because I've already disclosed it. What I don't want to do is file and get a patent on the vessel and have somebody else get a patent on all the things I need to go to market. That's effectively stolen my invention. It's prevented me from going, so it forces a cross license. This is an example of a patent map showing what could be a picket fence. This was one of the Ring doorbell patents. That's the single patent on the left. You see the color, all the red patents? That was from a company named Skybell, who managed to patent a whole bunch of stuff around the basic Ring patents. It turned out there was some good discussions about how they were going to resolve that problem before Ring was acquired by Amazon, I think it was, right? So you don't want to picket fence. Now, evolving patent strategy, I said I'd come back to Tesla. Tesla made a big news because they said, we're going to make our patents available to anybody under certain conditions, but we want to share them because Elon Musk is such an open source kind of guy, right? Why would they do something like that? Well, Maybe it's patenting to enable a market. When Henry Ford had the Model T, he wanted people to be able to use it. What else do you need in order to have a viable market for automobiles? Well, you need somebody to figure out how to get the fuel, oil wells, refinery, distribution. There weren't gas stations originally. You would actually go to a grocery store and they'd fill you up with kerosene or something. And you might want somebody to build roads and other things. He doesn't have to own all of that. If other entrepreneurs can come in and do that, they enable the system that allows them to sell a lot of cars. Same kind of thing, I think, goes on with the Tesla if you look at their patents. They have a whole bunch of things on charging patents. If they get other people to build them out, unfortunately, not many people did yet, but I guess that's picking up. You might say if you're a nonprofit, why would you get a patent if you're a nonprofit? Well, you might want to control how other people, try to implement your technology, the technology that might be part of your nonprofit. You don't want people, you have a vision of how you want to deliver that product or service to those people that you're trying to help out, that if somebody else came in and could screw up the market, you might want to get a patent on it. So it has some application. Then if you think about, as you think about a strategy, do you have a core technology you're trying to protect? Do you have a product that can be easily reverse engineered? In which case you might want to patent that. How long is the lifespan of the product and the speed of the market? What's your business model? If you're going to manufacture and sell, maybe you need a patent, maybe not. If you're going to license or partner, yeah, they're going to want to see a patent. They want to see a moat around the investment they're going to make. With our consumer products company, they were going to put in hundreds of millions of dollars, and they wanted to make sure that what they were investing in was protected. There may be other barriers to entry that you don't really need a patent if they're regulatory or others. And then what's your exit strategy? Are you going to sell the package, including the patents? Things to think about as you think about IP. So here's a practical checklist for employees: invention, disclosure, and assignment agreements to make sure the company owns the patents and copyrights that may come out of the invention and work that's done. Especially with the consultants, make sure your outside consultants, if they're doing stuff for you, you own the rights. And non-disclosure agreements, where you can get them to protect trade secrets. And maybe you haven't filed your patent applications yet. You want to avoid infringement. You don't want to infringe others. You want to understand the patent landscape. And there's some tools there that I showed you, the IP vision that helps with that. You want to preserve the rights. Think about provisional applications as a way to preserve rights. Make sure you file before you disclose. And think about disclosing in the right circumstance to prevent a picket fence. In dealing with any lawyers, but in this case, talk about IP lawyers, lawyers and law firms bill by the hour typically. And I'd hate to think my daughter was with a law firm as a 6-year associate. I think her bill rate was $750 an hour. If my bill rate, if I were back in the law practice, would probably be in the multi-thousands per hour at this point. So you don't want to waste the time. You don't want to bring up time for things like that. You want the lawyer to do the things that are important. So in the case of a patent, for example, the lawyer's ability to write those strong claims is what you really want to pay for. So if you walk in and say, here's my lab notebook, write me a patent, that's going to be very expensive. But if you, think about what the structure of a patent is, you describe what the problem is, you write up a lot of it, and be as clear as you can, and then say to the lawyer, now how can we get claims to cover these kind of things? That way you can be much more efficient. Also, make sure you're not waiting to the last moment. We're going to a trade show. I got to get this on file. Well, that's going to cost you more. I have a thing called 10 Commandments of how to work effectively with lawyers. It's in the materials for the class at the website. I think you'll find that helpful. Now switching to university licensing, because we're here in a university and a lot of things going on here. Federal government funds a lot of research. And back in the, before the Bayh-Dole Act in 1980, the federal government owned any rights in any research funded by the federal government. And Senators Bayh and Dole realized that only about 5% of all the work that was done and funded by the government ever got patented or commercialized. And they said there may be a better way to do it. What if we gave the rights to the inventions to the university, and we made them have an obligation to try to commercialize? And they also need to make sure that small entities can do it, because startups get to market quickly. So what they did is they gave the rights to the universities. MIT has a technology licensing office, and they administer anything that comes from federal research or corporate sponsored research. Now, MIT's general policy for ownership of a patent or copyright is if significant use is made of MIT facilities, or MIT administered funds were used, either federal or corporate, then MIT claims ownership in it. They don't ever sell the invention, they only license it. That's sort of the basic thing. Now, they can waive invention for ownership of an invention if there are no sponsored rights, no significant use of facilities, and no plans to use facilities to reduce it to practice. What does that mean? You've got Kendall Square over here. So what typically happens is you have some core work done at MIT, and maybe a patent is filed, and you get a license to that patent, and we'll talk about that in a moment, and you go across the street to a building outside of MIT, and that's where you do all your development work. And you separate the ownership between those two. In addition, though, to where MIT has rights because of the use of facilities or sponsored research, there's a recognition that there are a lot of smart people running around, and they may have some really good ideas. So you could actually give your invention to the technology licensing office. If they accept it, then they'll prosecute it and do other things and license it. And that's one of the ways in which the MIT Technology Licensing Office has become so prolific, because of the ability to do these kind of things. Now, I'm going to show you some licensing terms in a moment, but think of it, you're thinking you're spinning out of MIT, maybe you're finishing your PhD, and you're going to leave, and you find out that there's some ownership of MIT has in the work that was going on in your lab. And you'd like to be able to figure out, how can I make sure I have a license to that? I can't afford it right now, but I'm going to go out and I'm going to try to raise money. And I'd like to be able to say, I have a right to get this. This is where an option comes into place. They'll write you an option to obtain a license, and typically 6 months to a year. There are some modest upfront fees. And this allows you to then go forth and talk to potential partners or financing sources saying, yep, here's my plan. Here's what we're going to do. Here's my team. I've got this option to get the license. We just need your money. And I've got these other people standing by who are going to jump on board once the funding comes in. You put the whole package together. So that's an important thing for startups. What does a typical license look like? Well, the components are, there's an issue fee. You got to pay something to get the license, sort of an upfront cost. There's a maintenance fee. That means every year or periodically, you might have to pay additional fees. You have to promise you're actually going to try to commercialize it. They retain the right to come in and take it back if you just put it on the shelf. There's usually a royalty as a percentage of sales. You have to pick up the patent costs. So what MIT does is it looks at all the things coming through and it will decide to patent some things, file applications, and they use outside law firms and they pay those. And so they have patents now or patent properties in the works. When you come and license it, you've got to pick up and reimburse for those fees. And sometimes you have to sponsor research. So here are, those are the components. Traditionally, licensing offices dealt with large companies who had money. And then the revelation, especially out of MIT, was a lot of the innovation and market stuff going on in small companies. And they don't have a lot of money. So the traditional no equity license would look something like this. Issue fees would be maybe 50 to 150,000. Maintenance fees would be 50% of expected running royalties. You can't leave the invention on the shelf. Let me put this back in. Royalty is a percentage of sales, maybe 3 to 5%. Patent costs $25K to 200,000. And there's no requirement for sponsored research. When a startup, a smaller company comes along and they decided, well, we could take equity as a way to enable some of this. So in that case, the terms look sort of like this. The royalties would be maybe 2 to 4%, so lower royalties. And the equity component would look something like a single-digit percentage ownership of the company, which would be maintained until the first round of financing was raised. In other words, if I give you 10% of the current, let's say I gave MIT 10% of the company, and then we raised some money, MIT's percentage would drop. Everyone gets proportionally diluted. Well, normally they would say, no, we want to maintain our 8% ownership through the first round. And thereafter, as additional rounds of financing comes in, and more shares are issued, their percentage would go down. Here are some typical royalties for university patents. Now, this is actually dated from about 15 years ago. I tried to update this. These were MIT kind of things. There are sources where you can find this stuff. They tend to be kind of expensive. I couldn't find an updated version. But it gives you some idea of the range of things. And you can see whether, where are you in, say, for pharmaceuticals? Have you gone through, how far have you gone through? Is your thing a small part of something else? Anyway, that'll just give you some idea. This will be on the deck when you get it. Okay, so that's sort of university licensing. Next thing, do we need some sort of entity? We're going to go out and raise money and deal with the public. Do we need an entity? Well, I have a whole presentation on various choices of entities, but for the typical technology-based company, well, if you do nothing and there's more than one of you, you have what's called a general partnership. A general partnership is one or more persons engaging in business for profit. And what it means is you have unlimited personal liability for the acts of your partner. It's called joint and several liability. Somebody could sue either one of you. And this is not a good thing for an investor. Why would I want to come in and be an investor? I'm the guy, the deep pocket money. If something goes wrong, guess who's going to get hit? Me, the investor. So I'm not going to invest in a general partnership. So I want an entity that limits my liability as an owner, and that would typically work out to be a Delaware corporation. Why Delaware? It's had a lot of history with corporations. It has a well understood corporate law doctrine. People feel very comfortable about that. And what it does is it doesn't, we're always liable for our own acts. So I've had people come in and say, well, I'm an inventor and I know I should incorporate so I don't have liability for my invention. Wrong. You know, if your invention is defective, you can be liable for that. But what if I invest as an owner, I'm not liable for that. I'm only liable up to the amount of money I could lose my investment. You should incorporate sooner rather than later to avoid personal liability and minimize Section 83, which I'll come to in a moment. Once you do incorporate, you actually have to treat it like a real person. A corporation is really a person in the law. It has rights. So you have to treat it as one. Use the corporate name, maintain records. Don't mix, your personal checking account and the company funds. Treat it as a separate entity. For most tech startups, think about it. We're going to raise money. We're going to use the money on R&D, right? We're probably not going to have any profits. And at some point, hopefully we go to market and succeed. An S corporation is a corporation where you've made an election under the federal tax code to say, we don't want to have the corporation taxed at its level. We'll flow the taxation to the individual shareholders. And I'll show you an example here in a moment. You have to qualify for this. You actually have to file. You have a corporation and you file an election form. You have to have fewer than 100 shareholders. You can only have one class of stock and a couple of other things. You can't have, all have to be individual people. You can have corporations as shareholders. And we can't have foreign nationals as shareholders. But here's what it means. The losses flow through while you're doing R&D. They can't really be used by most of the investors because they're not active. The real thing comes when the acquisition occurs. Often what will happen is a company will come along, especially for smaller deals, they'll buy the assets of the corporation. And if they did that, there would be a tax at the corporate level if it were C Corp. So let's say if you had, well, here's an example. If you had profit of 100,000, corporate tax rate would be 21, netting 79. The individual tax rate, 37%. You'd effectively have a 50% tax rate to the shareholders. If you were a C Corp, you'd have a 37% if you were an S Corp. So anyway, that's an important thing. Remember I talked about Diva the other night? The video editing company. They said at the beginning, well, we know we're going to want venture capital money, so let's not worry about S Corp. I said, humor me. Let's do it. They sold the company in 2 years without ever raising outside money, and they ended up saving about $2 or $3 million in individual taxes because of that S corporation election. So that's my default suggestion. When you actually do it, you're going to be talking to someone looking at your position. Okay, now here's the third thing that I said you really have to be careful about so you don't trip up for startups. It's called Section 83 of the Federal Code. And it says, if you receive property in connection with providing services, you have ordinary income, which is taxed at rates up to 37%. It's equal to the fair market value of the property you received minus what you paid. So let's say we haven't incorporated yet. You come to me and I like your idea, and I said, I'll tell you what, to make the math easy for this purpose, I'll give you $1 million for, I don't want half the company. We're on Shark Tank, right? And so you agree. And we're going to set the company up and we issue stock. Stock is property. So when we set the company up, you, the entrepreneur, are going to get 50% of the company. How much did you pay for it? For the stock? Probably nothing, right? What is your 50% of the company worth? Well, you could say, I got stuff worth, you know, I have ordinary income of $500,000. And the tax, call it 40%, just to make the math easy. Yeah, you owe $200,000 in taxes. Whoa. But wait a second. If you have, if I gave you $1 million for half of the company, what's your half of the company worth? It's $1 million, right? If I gave, you know, right? Why would I buy half? So maybe your part is worth $1 million and your tax rate turns out to be you owe $400,000. So just pay that. That's a bad result, right? You're following? You don't want that. Okay. So when do you measure this Section 83 income, just to make things worse? Well, you typically, if I'm investing in your company, you've come and you made a great pitch. And I say, okay, I'll put the money in and you're going to what? You're going to do everything you said you're going to do. So, but how do I make sure you're going to do that? Well, I would like your stock to vest over time. So if you actually leave, some of that stock comes back, right? Because when I put my money in, I've done everything, you know, I'll help you out, of course, but you know, when you cash my check, I've done my deal, right? So typically we would put vesting here, and under 83, you measure the value of the property, the stock, when you get it, unless there's a substantial risk of forfeiture, unless there's vesting, in which case you measure it when the vesting kicks in. So hopefully, if everything's going well, the value of the company is going up, right? Because you're working hard and you're taking the money. And now you kick in and there's all of a sudden you've got something that's worth a lot more money. That's not a really good result, because think about most of the times you get taxed, it's because you got cash. You know, you go to work for a company, you get a check, they take all the tax out, but you still get cash. This will give you a tax event without cash. All you have is a piece of paper. So what you want to do is file an 83B election, it's called, which says, I want to measure my, if you have vesting, I want to measure the income today, not when the vesting kicks in. You have to file that within 30 days of the time you get the stock. So remember 83B. So how do you avoid an 83B problem? Well, if you can separate the time from when you got the stock to when something that valued the stock higher, then you can argue, well, look, ideas are a dime a dozen. We set up the company today. Now we're out scurrying around trying to raise money. And 6 months from now, you know, somebody invests, you know, the further the time you separate the two, the better. But if you come in and say, oh, I'm going to incorporate today, we're taking the money tomorrow, how are you going to argue that it isn't worth what the money that's coming in? So the trick is to get it earlier and make the election. Now the question is, why does stock not get issued early on? You saw this the first night. Maybe we haven't figured out who gets what. Maybe we're having a discussion about the technical and business person, you know, who's going to get what percentage. We procrastinate. Eventually we're starting to raise money. Now we got to issue stock. So we finally make some agreement with it. But, you know, now we're so close to the time we raise money, we're falling into the 83B trap. So does that make sense? So 3 things to remember. Make sure you own the rights with you know, outside contractors. Make sure you file your provisional application before you disclose. Make sure you've, you know, issued stock and done the 83B, that kind of thing. Those are the 3 takeaways. All right, how far are we going to get here? Just picking up on the earlier discussion tonight, founder's journey. If we go to the last couple of bullet points here, restrictions on stock transfers. You know, we're all in this boat rowing together, and we don't necessarily want to we want to restrict the ability to transfer stock to other people, because we're a team. So there's typically going to be an agreement among shareholders about, what happens if someone wants to sell. What if we have a dispute? There's a memo I wrote that Mindy mentioned the other night. It's on the website, called the Founders Memo, that lays out all of the things that you should think about that might go into a founders agreement. Founder equity splits. First of all, there's culture negotiated. Keenan Systems was a company that an MIT Sloan professor had. He owned 100% of the company. He sold it for $1 billion. None of his employees had stock. He treated them very well, gave them plenty of money as they went along, and actually gave them bonuses on the sale. The culture there was he was the owner, he was the king, and he also got rich, to pick up on what Ken said. But I think for most of the markets you're in, people are expecting some form of equity. So how do you think about splits? Well, the value of past contributions. I developed the technology so far. Who's going to do what for the next few things? So maybe it's a professor's work coming out of MIT, but you're the co-founder and you're going to be doing all this work and not get paid. There must be a value to that. Sacrifice and commitment. I had one situation with an MIT professor and a postdoc, and I asked them to go and write down, what they thought they were giving up. And the professor said, well, look, I have 1 day a week I can consult, and here's what my consulting rate is. I'm giving up this much income. If I agree, I'm going to spend all my time free time working on the company and a couple other things. The postdoc said, well, I could make this much money if I went into industry. I'm giving up my, for the time being, my potential to be an academic. And, this and that. And when they saw each other, picking up on Mindy's things, they were able to come to some description of what they should get. Typically, I've seen, in academic things, if the professor co-founder gets more than 20%, that can be a lot. Each situation is different, though. Now, as you're thinking about planning, looking at the time, I think I can get through this slide. When you're going to have next week, we're going to have a session on financial planning, and part of that are projections, and part of that's going to be what team do I have to build, how many people, when are they going to come in, and how much equity do I think I'm going to need to give up to each. And the question is how big should an equity pool be for rewarding those? And it's typically it's the first 2 to 3 years in the headcount plan, and for a first round outside financing that's significant, in my experience, somewhere between 12 and 18% of the company is reserved for all of those hires you're going to be making. The founding team has its own piece, but the people, so you got the money and now you're going to start hiring people to execute on the plan. Who's eligible for equity? It could be key employees. It could be everybody. Could be directors, consultants. And just determining the size, there are compensation experts and surveys you can find out for what equity people get. And I did a YouTube fuller discussion of this that you can click on and look at. This is typical. Charlie Tillett, who normally does the financial projections, can't do it this year, but so we're going to be using some of his slides. This is typical ownership after 2 rounds of financing. And by 2 rounds, I mean, we're talking about not 2 small rounds, but 2, significant rounds. And this is not atypical, where the CEO might get 5%. The VP might be 1 to 2.5% after the rounds. And if you're a founder, you have more, obviously, and you can always grant more later. In Charlie's deck materials, there's actually a little equity plan template where you can, say, if we raise this much money, what's the dilution look like? The forms of equity compensation, restricted stock, which means you get the stock outright, in which case, if it's early on, you and the value's low, you file the 83B election, no problem. But now if you've raised a round of financing and we're going to give you stock, then that round of financing is going to value that stock and you're going to have to pay taxes on it when you get it. So typically people switch to options. And there are two types. Incentive stock options have special tax treatment. They're given to employees. There's no tax when you get the grant of the option, and it only get taxed later when you exercise and sell. And there's some rules that I won't be able to cover tonight, but I'll show you on that video. Non-qualified options you could give to anybody. It could be employees, but typically non-employees. And, I think I'll stop it right about there since we're almost at the hour. I will post on the website these slides. And I'll also post, I made some shorter YouTube videos covering some of these slides. And I'll post there. And if you want to see things like restricted stock, stock options, and then later on, all this stuff. And then when we get into here, description of securities law, there'll be something on that. I'd rather you have these all, and then capital structure instruments, by round of financing. And then eventually it'll lead into financing type things. This is actually worth for a moment just so you understand the term. Typical venture capital will come in using what's called preferred stock. It's sort of a big deal. It's a lot of legal documents. Two ways that people have raised money before that. One is a convertible note financing, in which you take the money and that note will convert into stock when the first outside round comes along. There's some pros and cons for that. Another one is something called a SAFE, a simple agreement for future equity. The same thing, the convertible note is actually a note, and there's some question about whether the interest that you're supposed to pay on the note accrues and is taxable to the investors. There's a SAFE, and also if eventually, somebody could come in and say, pay me the note back, in which case it's an obligation to the company. A SAFE is simply an agreement that says, when we raise additional money, your money will go in on these terms alongside that money. And there's some examples that you'll see about that. And then I go into actually the terms of a venture round, again, in that video. So with that, I've rushed through a lot. Hopefully some of it's stuck. Remember the three things: outside contractors, make sure you own. Make sure you file an application early if you're going to have something patented. And do the 83B. Make sure you don't get caught in the 83B trap. The rest of the stuff's important, but those are the ones that'll really trip you up if you're not careful. So with that, we'll see you next Tuesday.